पूर्णमेवावशिष्यते। ॐ शान्ति शान्ति शान्तिः।
Thank you so much for your wholehearted participation. We experienced an overwhelming participation in the inaugural as well as the 5 plenary sessions of the first International Symposium on Law and Peace, organized by MIT World Peace University in association with the Pune District Bar Association. Well, as a matter of fact, we all know how markets are governed by different regulatory mechanisms. One of the important objectives of the mechanism is to strike a reasonable balance between the conflicting interests among the various stakeholders. The legislations are one of the chief components of regulatory mechanism, which in its concerned areas try to balance between the free play of monopoly rights and interests of the society. Ladies and gentlemen, I once again welcome all of you to the 6th plenary session of ISLP, which is on the theme, what creates the conflict between IPR and competition law? A global perspective. So believe me, we are about to witness an interesting deliberation by all the dignitaries present on the online days. Dear participants, it's my privilege to welcome the moderator of this session, Mr. Divyendu Verma, partner and patent attorney in IPS, IP firm, California. I would like to introduce her shortly along with all the speakers in the panel. Mr. Divyendu Verma, advocate and patent TM attorney, managing partner.
I think there's some technical. Yeah, we missed you for a minute, Pranima. Okay, so I'll take up the proceedings from here. So, yeah, I think Dr. Pranima is facing some issue. So, respected dignitaries on the dais, distinguished honorable members of legal fraternity who are attending this meeting online, as well as those who are present here, respected Honorable Chief Justice, Honorable Justice of Supreme Court, High Courts, Honorable Sitting Judges, Honorable former judges, distinguished senior advocates, members of Bar Association, advocates, lawyers, fellow colleagues, participants, members from media and press, faculty, staff, and my dear students. Very good evening to one and all as per Indian Standard Time, and it's 4:30 here, 4:36 in fact, as per Indian Standard Time, and I extend heartfelt greetings to all of you as per your respective time zone, and welcome one and all to this technical session on IPR and competition law, the poles apart. And Dr. Vishwanath Karad, MIT World Peace University, Pune, Bharat. MIT World Peace University is organizing this International Symposium in association with Pune District Bar Association. And this symposium, it was started on 14 December 2021 with a very grand inaugural session. And after all 8 technical sessions, we will be concluding the symposium on December 17, 2021 with the valedictory. And the theme of the symposium is Role of Law to Promote the Culture of Peace. And at the outset, I wish to express gratitude and thanks to good number of people who has blessed International Symposium on Law and Peace with their valuable contributions. So I wish to express gratitude and thanks to Honorable Revered Professor Dr. Vishwanath D. Karad, President, MIT World Peace University. We express gratitude to MITWQ International Symposium on Law and Peace patrons and organizing chairs, Honorable Executive President Shri Rahul V. Karad and Dr. Lalit Bhasinji. Thanks to Professor Ravi Kumar Chitnis, Vice Chancellor MITWQ. And we also express gratitude to MIT World Peace University School of Law Advisory Board members Shri Nanik Rupani, Justice Dilip Karnik, Advocate Makarand Adkar, Advocate Satish Manishinde, Advocate Anand Desai, Advocate Aniket Nikam, Advocate Ravi Kini, and these are the people who are there for our MITWPU School of Law. Advocate Rajendra Shirodkar, Advocate Mohan Pungalia, who is also one of the advisor, Advocate Mrunalini Deshmukh, Professor Dr. K.L. Bhatia, Professor Dr. Dilip Uke, Advocate Sudhir Vakure, Advocate Anita Agarwal, Advocate Aditya Pratap, Advocate Komal Joshi, Advocate Kapil Khair, and Advocate Satish Mullik. I also take this opportunity to welcome and express gratitude to all distinguished luminaries from legal fraternity who are here to share their perspective at this prestigious platform of International Symposium on Law and Peace. So all legal luminaries who are gracing right now the virtual dais of International Symposium on Law and Peace, and we keenly look forward to your address on IPR and competition law, the poles apart. Thank you, Vande Mataram, Jai Hind. With this, I hand it over to Dr. Pranima for introducing the speakers.
Thank you so much, ma'am, for your very significant insights. And extremely sorry for the technical glitch, but it is indeed an honor to introduce such a distinguished panel. And with this flow, I would just like to mention that I'll be introducing all our distinguished guests in the panel, after which we will definitely request Dr. Rohini Kale ma'am to propose the welcome address. So, ladies and gentlemen, it is my privilege to welcome the moderator of this session, Mr. Divyendu Verma, partner and patent attorney at InnoIPS IB firm from California. Mr. Divyendu Verma holds an LLB degree from Delhi University, diploma in intellectual property management from World Intellectual Property Organization, master's in computational mathematics from Bangalore University, an engineer's degree from Vishvesvaraya Institute of Technology, and a bachelor's degree in mathematics, stats, and physics from Allahabad University. He is the founder and president of Bharat Parivartan Initiative, as well as a senior analyst at Oracle Private Limited. Welcome, sir. Friends, we are deeply honored to have Professor Dr. Milton Ducideliao Barcelos, partner, lawyer, and patent and trademark attorney from Brazil. Sir is a member of the following national and international associations in the area of intellectual property. He is in the firm of Brazilian Association of Intellectual Property, Brazilian Association of Industrial Property Agents, Brazilian Institute of Intellectual Property, Association Internacional por la Protección de la Propriedad Intelectual, International Association for the Advancement of Teaching and Research in Intellectual Property, as well as International Trademark Association, along with Asian Patent Attorneys Association. Sir, it is indeed an honor to welcome you. Thank you so much for being present on this online days. Ladies and gentlemen, I feel extremely glad to welcome Dr. Leong Jin Hung, partner, advocate, and solicitor, registered patent agent, trademark agent, and industrial design agent from Malaysia. Sir specializes in intellectual property portfolio development. His practice includes the preparation and prosecution of all types of patent, trademark, industrial design, copyright, plant varieties, domain name, and other intellectual property issues, including pre-patenting investigations, patent litigation and support, prior art searches, patent drafting and prosecution. In addition, he has a rich experience with contracts of service, employment issues, industrial actions, judicial reviews, law on dismissals, employment law, retrenchment, as well as statutory benefits, and commercial, as well as corporate real estate, construction, etc. He has appeared extensively in the High Court, the Court of Appeal, for judicial review applications and appeals. He is now a partner in Messrs. N.G. Arlington and Leong following the merger of Arlington and Company and N.G. Carolyn and Partners. Welcome, sir. It is an honor to have you. Dear delegates, it's indeed my great fortune to now welcome Mr. Dennis Duncan from US Patent and Trademark, Attorney Managing Director at Essentiality Check Consultants, LLC, New York, and ex-chair of Emerging Technologies Committee of American Intellectual Property Law Association from Washington, D.C., and ex-senior IP counsel at Dolby Laboratories, San Francisco, California. Mr. Dennis Duncan is the Managing Director of Essentiality Check. Prior to this, he was a senior patent counsel at Dolby Laboratories, where he manages a global patent portfolio. Prior to joining Dolby Laboratories, Dennis was an associate with the intellectual property firm of Scully, Scott, Murphy, and Presser. Welcome, sir. Thank you so much for joining us. And now I feel really elated to welcome Jae Joo-hoon Soo from South Korea. He is from South Korean Patent Trademark Attorney Partner and U.S. Attorney at Law at Sung Am Soo International Patent and Law Firm, South Korea, as well as the member of the New York Bar Association since 2006, along with it, member of American Bar Association. Jae-soo is a U.S. attorney at law and a partner at Sung Am Soo International Patent and Law Firm, heading the International Patent Division of the firm. He worked over 9 years for prosecution on standard and strategic patents for a global electronic corporation. He also has vast experiences in areas of IP, including trademark infringement litigation, patent infringement litigation support work, as well as giving tailored IP strategies and services for SMEs and government-affiliated institutions. He is fluent in English and Korean, has high proficiency in spoken Chinese, and therefore he can promptly communicate with foreign associates when urgent matters come up for those clients. Welcome, sir. Thank you so much for gracing this event. Friends, it is indeed our honor and privilege to have such a distinguished panel. And I now kindly request Dr. Rohini Kale, the head of school from School of Polytechnic, MIT World Peace University, to kindly propose the welcome address. Ma'am, over to you.
Thank you, Dr. Bharti. A very good morning, good afternoon, good evening, one and all. Greetings from Dr. Vishwanath D. Karad, MIT World Peace University, Pune, Bharat. It gives me immense pleasure to welcome you all for the first International Symposium on Law and Peace, Role of Law to Promote the Culture of Peace. On behalf of UNESCO Chairholder, Founder, and Chief Patron and President, MIT WPU Pune, Bharat, Revered Professor Dr. Vishwanath D. Karad, sir, and on behalf of Shri Rahul Karad, sir, Managing Trustee, Executive President, MIT WPU Pune, Bharat, on behalf of Dr. Chitnis, Vice Chancellor of MIT WPU, all faculties, staff members, and students, a warm welcome to you all. Intellectual property is the product of a person's intelligence, creativity, hard work, and skill. It results from an idea that comes to one's mind and is given creative expressions. Intellectual property allows consumers to make choices between competing entrepreneurs and the goods and services they sell. Therefore, IP is inherently pro-competitive as it ensures the protection of differentiated intangible business assets. This is 6th session, namely IPR and competition law. For this session, we have Mr. Devendu Verma, who is a partner and patent attorney in OIPS, IP firm San Francisco, as a moderator. Warm welcome to you, sir, for your distinguished presence here. We have a galaxy of speakers. We have Professor Dr. Milton Lucidio Leo Barcelos, who is a partner, lawyer, and Patent and Trademark Attorney, Brazil. Welcome, sir, for your gracious presence here. We have Dr. Leong Jin Hung, who is a partner, advocate, and solicitor, registered patent agent, industrial design agent, Malaysia. Welcome, sir, for your eminent participation. We have Dennis Duncan with us, who is a managing director at Essential Check Consultant, New York. Welcome you, sir. We have Jay Su, who is a member of American Bar Association, South Korea. Welcome, sir, for your eminent presence here. I am sure all participants will enjoy and learn a lot from this session. Once again, I welcome you all. Thank you. Over to Madam Mac.
Thank you. Thank you so much, ma'am. Before we proceed, I would like to request all the panelists to kindly turn on their cameras and wear a beautiful smile so that we can capture this special moment that we are experiencing of heralding law to promote peace. I request my technical team to take a group photograph. Well, that's an amazing view that we have, a very interesting conglomeration of all the experts along with our student volunteers from School of Law at MIT World Peace University. I'm sure we have captured this special moment. Thank you so much. Dear delegates, we are now heading towards the 6th plenary session. This conference, being organized under the leadership and guidance of Executive President of MIT World Peace University, Sri Rahul V. Karad, is envisaged to initiate dialogue between lawyers, judges, policy makers, jurists, academicians, youth, and industry experts. I now kindly request my technical team to relay a short film on the theme of this session. Over to my technical team.
Intellectual property rights and competition law are two distinct fields of law that have become of paramount importance, especially in the ever-growing corporate industry, with upcoming entrepreneurs, established businessmen and innovators competing in cutthroat competition in a bid to win over the consumers in all fields ranging from agriculture to information technology. Competition law governs the companies and establishes standards to be followed so that cutthroat competition doesn't lead to consumers being affected by unfair trade qualities and under-quality goods. IPR protects the businessmen and innovators by safeguarding their unique business creations from being copied or misused by anyone. While in theory, these laws may not seem related to each other, in reality, they have led to one big common incentive for the final consumer: a competitive and innovative developing market. These laws have become the perfect recipe to ensure innovation in compliance with ethical and legal standards, combined with the legal protection to protect the efforts that go behind them. This session will discuss the interface between intellectual property rights and competition law.
Well, thank you so much. That has indeed set the tone of this session. And I would now like to formally hand over the session to the moderator, Mr. Divyendu Verma, Partner and Patent Attorney from INNO-IPS, an IP firm at California. Sir, over to you. Sir, may I kindly request you to unmute yourself?
Thank you so much for handing over, Dr. Bakshi. Before I start, I have a clarification to make here. I represent INNO-IPS India, not California.
Sorry for the mistake, sir.
Again, I welcome my colleagues, Dennis Duncan, Dr. Milton, Dr. Leon, Jeshu, to the panel. And given the kind of experience my colleagues have, I'm sure we are going to have a really nice panel discussion. So as I wanted to understand, from the kind of theme which we have selected for today's discussion, where we are going to primarily focusing on IPR and competition law. So here we are with a team of 4 panelists, which we are going to discuss in detail about what kind of things which creates a conflict between IPR and the competition law. And since we have speakers from around the world, so I'm sure we will have the global perspective. So before I just hand over the session to my like fellow panelists, I just wanted to just provide a kind of introduction, just to set the tone clear and straight. And probably I need not to mention, but given the kind of audience we have, I thought like just provide a little bit perspective from the Indian perspective. So here, like since we are talking about a very interesting topic where we are talking about IBR and competition law, so I thought I'll just provide a little bit basics to the students of university, ma'am. So I would like to say the answer. I mean, probably the question to the answer of the topic is here. I mean, when you have the IP, this gives the IP owner to right to exclude others from using that invented subject matter for a limited period of time, right? And when this advantage, when you say advantage, or you can say the dominant position, when this is abused, it creates a conflict between the IPR and competition law. So that set the stone for the whole discussion. We are going to hear from my colleagues from different perspective. So I give the answer for today's topic, and I'm like in India we have the Competition Act, and in order to ensure such conflicts should not arise, we have anti-competition law, which combat the IPR monopolies. And these kind of anti-competition law often includes two kind of important measures, which is like address this kind of a conflict. One is the compulsory licensing and the parallel imports. I'm not going to talk about much on these topics because these topics have the potential to have independent session on these. But just to like provide a little bit an idea how these things can be managed, there are checks and balances there in the law, which like keep the balance on the same platform. Since I'm talking about from the Indian perspective, so I would like to mention upon about two cases through which I'm going to demonstrate how this kind of conflict may be created in past, and how the courts of law has addressed this. So before going into complex thing, I would like to start from the trademark laws perspective. So we had very interesting case back in 2012 in Delhi High Court. That case was Hawkins Cooker Limited versus Murugan Enterprises. I'm sorry, guys. I'm just trying to directly jumping on the subject matter because we have a lot to cover, and so I thought rather than wasting time, simply address the issue. What is the issue? So in that case, when the Hawkins Cookers Limited versus Murugan Enterprises, when this case was filed before Delhi High Court back in 2012. So what happened that Hawkins Cooker Limited is the owner of the trademark called Hawkins, and Hawkins is by the way very famous trademark in India for the pressure cookers, right? And this trademark basically Hawkins company used on several products, including the cooker pressure, gaskets, many things like. And then the Murugan Enterprises, they are the manufacturers among many things about the gaskets for the pressure cooker, and they uses the Hawkins trademark in respect of the parts of the pressure cooker to establish the compatibility. They say that the kind of gasket they manufacture is compatible with the Hawkins pressure cooker. And because of this kind of claim, like Hawkins company, they aggrieved by this kind of a claim, and they approached the Delhi High Court. There is an infringement of the trademark, right? So like they filed a infringement suit against the Murugan Enterprises. They were having a lot of arguments. I'm going to cut down everything. Just coming to the core point, what happens when it was like Murugan Enterprises, they opined in the case that they have their own well-established trademark called Mayur, which like has the prominent peacock, Indian peacock, displayed on the product listing. So they say that I already have a very well-established and distinguished trademark. I need now to like use your trademark to like market my own product. And while listening all the arguments, Delhi High Court held that no reasonable person or purchaser could assume a trade connection between the Mayur brand of the gasket, which is owned by the Murugan Enterprises, and the Hawkins brand of pressure cookers. So while passing this order, Delhi High Court, the order was passed by Justice Kaul. He was one of the great High Court judges from Delhi High Court. He pointed out that the object of filing this suit appears to me is to create a monopoly over such gasket ancillary item so that no third party is able to sell the same product in the market. So the kind of what I'm trying to make you understand how this conflict may arises in the business, in the competition, Like, when you're trying to overreach your over the production which is granted by the IP laws to you, right? So we have lot of cases, and in the last 10 years, India has seen many cases where, like, many foreign companies, they own the rights in India, IP rights in India. They try to abuse their position. I'm not going to take into those talking about those in details, but I would like to hear to mention about a case happened between the Ericsson versus CCI, Competition Commission of India, back in 2016, where, like, a single bench of the Delhi High Court had discussed various provisions of the Competition Act. That was the first time, but there was first time Delhi High Court had discussed about the various provisions of the Competition Act as well as the Patents Act, and they try to see whether there is a balance between these two acts or not. And after that, they come to conclusion these acts has been enacted in addition to each other. So there is no substitution, therefore, and therefore there is no conflict as such in these cases, right? So that court, Delhi High Court in the Ericsson versus CCI back in 2016, has concluded that the jurisdiction of the CCI to entertain complaints against the abuse of dominance in respect of the patent rights could not be excluded. So I request everyone to read this case. This is a very interesting case to understand whether what is the role of CCI and how they can exercise their role, right? And one very recent case happened in the middle of the pandemic last year in 2020, May 2020. The parties were Monsanto Holdings versus CCI. Delhi High Court in May 2020 has prolonged the decision, and Delhi High Court held that in that case, in case of the abuse of the patent rights, the Competition Commission of India, which is the governing council of the CCI, could directly examine the complaints without any prior determination by the controller of patents. So basically what happened, this Monsanto has approached the Delhi High Court, and they said that the CCI has no jurisdiction over the complaint and to investigate the matter. So the High Court made it very clear, whenever there is a case of abuse of the patent rights, the Competition Commission of India, which is CCI, they can directly examine the complaints without any prior determination by the controller of patents. This is the, I would say, the landmark judgment in this case, because in India we often see many companies, they approach the high courts and they talk about whether the CCI has a jurisdiction over to investigate this and that. So there are many things happened in past. In this particular judgment, a single judge has dismissed the petition challenging this investigation order by CCI, and the judge has reaffirmed that there is no conflict between the Competition Act 2002 and the Patents Act 1970 of India. And specifically, the court said that the CCI has jurisdiction to entertain complaints regarding abuse of dominance in respect to patent rights, and such complaints could be examined by CCI without the requirement of reference to the controller of patents. So this judgment, I would say, is a very interesting judgment, and I request everyone who has not gone through the judgment to read and understand the nuances in the kind of detail the Delhi High Court has, they have gone and they produce a fantastic decision. So the point is, this is very basics. I'm telling you, this is very basics. The kind of subject, the topic Dr. Milton Dennis is going to touch upon is very high level. But this is the beginning, and with this kind of introduction, I like this stage is set. I hand over to Dr. Milton to start with his perspective on this conflicting scenario and what he thinks. Over to you, Dr. Milton.
Thank you very much. It's a pleasure to be here with you all. Thank you to the organizing committee for the invitation and for the organization. Thank you and congratulations to MIT World Peace University School of Law and Pune District Bar Association for this event, for this symposium. Thank you, especially Divyandu, for the invitation and moderation of this, may I say, challenging panel. And it's a pleasure to be here with the other speakers, Mr. Dennis, Mr. Jay, and Dr. Leong. So thank you for being part of this panel with you all. I did prepare some slides. I will share my screen with you all. Let me see if I cannot share. Can you
yes,
make
sir.
me
I request my technical team to kindly make Sir the co-host so that he can share his screen.
Okay, thank you very much.
Yeah.
So let me see.
So I request the technical team to make co-host all the panelists, so each one can share their presentation. Thank you.
Yes, sir.
Oh,
Sure.
now I can. Thank you very much. Can you all see my screen?
Yes, sir.
Okay, thank you. Well, so this is since we have like about 15 minutes to address the topic, I will try to do it as fast as I can, and I will leave the time for discussion about some interesting questions that I will address for the end of the panel for the Q&A. So I will, in a nutshell, I will address the IP rights and competition law, the reasons to exist and goals to accomplish. Since I'm the first speaker, I think it's interesting to address those points. Then I will address basically two specific cases that we can see in the worldwide point of view, and another one in more a specific point of view of Brazilian competition law that deals with spare parts and aftermarket IP rights enforcement, and what we had here in the past in the divided opinion related to how to address that from the IP rights perspective and from the competition law perspective. Then I will address a little bit about the patent term extension and how long the patent term should be or could be. Those questions are really interesting for the Brazilian decision, the Supreme Court decision that it was addressed in May, last May 2021. And then some conclusions about it. First of all, when we think about IP rights and competition law and the reasons to exist and goals to accomplish, I like to use an analogy about the subway. When we create a subway in a specific city, we have some reasons to create the subway and some goals to accomplish. I have to bring someone from one point and to another point in a way, in a fast way, in a cheap way, in a way that I can accomplish that goal. When the city starts to grow, and we can see around the world, it's not different, the subway starts to have additional lines and starts to have another reasons to exist, another goals to accomplish. In the IP rights and competition law, we can draw a line that it's not that different. We must adjust the rights for the reality, but we cannot lose the main reasons to exist and goals to accomplish. This seems to be basic, but I really like to address that in order to make this discussion really deep. So every IP right has one or more reasons to exist and one or more goals to accomplish. Market failure solution, spur innovation, is that the reason to exist for an IP rights is what we are looking for on that. And how about the competition law and the relation with the free competition principle? Peace between individual economic freedom and public interest, so how we balance with them. So those questions are important. And I like to use this frame, this image, to say that usually we try to see things in the same way, but when we look at the real thing, we can see differences. But many times the law addresses different facts, trying to put in the same way to address them. So if I have different trees, I will not have the same shadow for the different trees. I will have different shadows. So that's one point that I like to address in the Q&A and the discussion part of the panel, in order to think a little bit more about how competition law works. Competition law works in the way that we must take a look on the specific market, the specific issue, how the behavior is being done. And sometimes IP rights we look at in a stable way. We looked at in a way that we do not treat differently the differences. So this is an important issue to think about it. When we go directly to the case that I want to address about the spare parts and aftermarket IP rights enforcement, we had in Brazil a case that most of the jurisdiction, we had the same case, and the different solutions for the same case is about the spare parts and the way that the automobile industry can or cannot assert those industrial property designs against the aftermarket, so against the manufacture of spare parts of the industry. So I took one part of the leading vote related to the majority of the competition authority case that it was judged, ruled by 4-3. So it was really tight, a really intense discussion about the possibility of enforcement of the industrial designs in the aftermarket. And the leading vote, it's more than 40 pages, but I can extract at least this part to make that a point for discussion. The exercise of industrial property rights can restrict static competition in the short term. However, the protection of these rights has to generate dynamic efficiencies that, in the long run, meet the social interest, including consumers and the country's development. In practice, it is an exclusive right given to its holder for a fixed period in order, above all, to encourage the creation of new industrial designs. Definitely, innovation appears as a key element. So this was the vote, understanding that the industry, the automobile industry, can enforce their rights in aftermarket. Then we have the opinion from the federal chief prosecutor, Victor Santos Rufino, that it was the leading opinion adopted by the minority of 3 votes of the administrative judge of the Brazilian Competition Authority, that this opinion adds to the analysis of this administrative proceeding the finding that the represented incurring venire contra factum proprio. For those who are not aware of this expression, but is when I have a contradictory behavior, when I accept the behavior of some people for a long period, and then in some point of the time, I start to not accept it anymore without any change of the facts. So this is the venire contra factum proprio. Breach of trust in clear violation of objective good faith by trying to prevent the activity of independent manufacturers of auto parts under the allegation of legitimate exercise of industrial property right. So this was the vote. I'm leaving that for thinking as the way we can look at the post-thinking related to this challenging issue of apparent. I always says that it's an apparent conflict. It's not a conflict. It's the way that we see that. If it's they are made to be together, like complementation or complementary or something that we add to the legal system, but they do not conflict. They only conflict when we have abuse, when we have the misuse of some kind of IP rights. But in Brazil, we had this new 2021. It was really a good year when we talk about the legal year for cases in Brazil. That because we had the first case, it was judged by the Brazilian Supreme Court in more than 20 years. So it was the decision related to the sole paragraph of the Article 40 that relates to the possibility of patent term extension. This paragraph 4, it was made by the law of 1997. So since 1997, it was in force. But it was ruled now in May 2021, after 7 years of discussion, of hearings at the Supreme Court, and a lot of amicus curiae opinions from the one side or the other, that this patent term extension, it was not constitutional. That means that we cannot have more than 20 years from the filing date for a patent term in Brazil anymore. So that has a huge impact on the competition and a huge impact on the way that we deal with the possibility of have, for example, the authorization of generic manufacturing drugs in Brazil. It was a political moment that it was, I would say, good for this ruling from the Brazilian Supreme Court. And then we had a new act from the new law that is adjusting the rules for compulsory license for competition. In 2006, I wrote an article related to the problems for implementing the compulsory license in Brazil. And then I addressed a lecture in Oxford University in 2013 related to compulsory license as a threat or an effective tool. Which one is that? So compulsory license impacts directly in the competition law as a way to build as a way to fix some kind of abuse of dominant position or abuse of rights. But the implementation of the compulsory license has a lot of pitfalls. So this law of 2021 is looking to try to avoid those pitfalls and to implement, to make it easier, not easier in the law point of view, but the procedure point of view to make it easier to be implemented. As a conclusion, since we have just 15 minutes and I like to keep that sharp, and I hope that we have an intense discussion after my colleagues speakers. But I think, and related to the symposium, and I really enjoyed the name of the symposium, Law and Peace. But when we talk about the law and peace between IP rights and competition law, we can find that peace could be reached with market behavior analysis. I believe that we should take a deep look on that instead of have standards that, of course, that we have standards, we have the guidelines, the conducts that are frequent, for example, DOJ and FTC guidelines of the US, and they are really helpful because it's previously we had some conducts that are frequent, and then you can draw the line that those conducts and those clauses on, for example, licensing agreements, they are abusive, and then you have the guidelines. But when I mean that, it's not when we are talking about per se rule, but when we are talking about to look at the behavior at the market before we can suggest that it's an abuse of IP rights or an abuse of the competition law. And for, as an end approach, I would say that understanding and applying the equality principle in order to differentiate the use and abuse of the IP rights, it's a different approach. Many people think that this is not the right approach to use the equality principle to draw the line. But I think if we think about the differentiation as the equality principle basic rule, we will understand better how we can apply the equality principle in the day-by-day market use of the specific goods or services that we could rule in a more case-by-case situation. So I think that's it for my introduction, because I think with this time it's only possible to make an introduction, and then I'm looking forward to learn from the other speakers, the remarkable speakers, and also to interact with you all during the Q&A. So I'll stop to share my screen and Thank you very much for your time, and it's a pleasure to be here with you all.
Thank you, Dr. Milton. It is really nice to hear from you. And I personally, I particularly like the phrase and how you correlated the topic with the peace and law and peace. Specifically, with the phrase "peace could be reached with the market behavior analysis." Really does that line. Thank you so much for the interesting introduction. So I'm sure Dr. Leong is the next panelist. He is going to add further more colors to the present discussion. Over to you, Dr. Leong.
Yes, thank you very much. Thank you very much for the organizing committee, especially from MIT World Peace University, and also the Attorney Dev Mendu for inviting me all the way from India. And I was provided with the topics, and I wonder what should I present. And I shared with Attorney Dev Mendu, and I said, why not just give you guys maybe a introductions, and also try to find any case studies in Southeast Asia region, because I believe if we're just relying on Malaysia, that would be a very small scale. You can't see the what is emerging market, the ASEAN perspective. Let me share my slide here. I can't share the slide. Anyone can help me? Host disabled person.
Technical team, can you please help Dr. Leon to?
Yes, sir. So we'll be giving you the sharing rights. If you can kindly check.
Yeah, I'm trying now. Still the same. Host disabled participant screen sharing is appeared on my screen.
Okay, so just give us a minute, and really apologies for the inconvenience.
No problem, no problem. Are you guys able to see the slides?
Yes, sir.
Okay, I try to magnify it. Okay. I can't much to say that we are very developed compared to most of the modern countries like US, Europe, and the UK. I thought that we would just to share what actually happened in this region, and try to let you guys know what are the things governing, and whether there's a conflict. Perhaps there are two questions has to be answered. The first issue is what creates conflict among these two, IPR and competition law? And the second question is, what is the impact if there's a conflict? Well, that's will be the questions. Let me run through what are the IPR laws and competition laws governed in this region. I make a conclusion after a thorough research that it seems to be some of the countries in ASEAN region is still remaining having competition laws quite recently, perhaps. You can see the year, and I will run through country by country. If you look at the Malaysia, this country that where I came from, sorry, and you can see that the law enacted in 2010, we have few cases, but these two cases are not related to IP. And the first case is the Competition Commission against Malaysian Airlines and AirAsia. This case is about the where two airlines are merging, whether that will cause any unfair treatment towards the public at large, whether there will be any profiteering when they merging each other. And the next case is Competition Commission against MyEG. This case is also not about IP. It is merely about monopoly of government services through electronic platform. Yeah. So overall, if you look at Malaysia, we have yet to see any cases here. The same applies to Singapore. You can see they do have even earlier than Malaysia in 2004, but at the moment there's no any conflict or case studies available. Yeah. And the same applies to Brunei. I try to locate, perhaps time will tell. And the Bruneian competition order was enacted in 2015. And they do have the IPR laws. As of today, there's still no any conflict form among these tools, perhaps for Vietnam too. And they do have competition laws enacted in 2018 under the National Competition Committee. And there's still no conflict at the moment reported. For Philippines, it is the same. They still on 2015 for Competition Act enacted, where the Intellectual Property Code first enacted in 1998. There is still no case reported. Something I need to highlight for Cambodia, perhaps they just have the competition laws this year. It was just, I think, enacted last month. I think it's November. So I think this is really very new to this country. So I don't see any case will be reported immediate soon. Yeah, and Indonesia the same. Although it is more than two decades here, yet to see any cases reported. And perhaps Indonesia is one of the emerging market that is around the world is looking at for, especially for manufacturing and productions other than Vietnam in Southeast Asia. And another country, Laos, they do have both IPR and law on competition business competition, 2015. Again, there is no case reported here. Same thing applies to Thailand, our neighboring country. The Competition Act was enacted 2017. Although they have the IPR law for more than 3 decades, it was still time to tell, see what there will be any conflict in Thailand. And lastly, in ASEAN region, what I can report is Myanmar. I think most of the practitioners and the panelists here, they do know that Myanmar have their own IPR laws in 2019. That opens, make it complete for the Southeast ASEAN having their own intellectual property laws, as this country is one of the last and the latest having the IPR laws. However, due to recently unrest and military coup, time to tell whether this law is applied to the public at large. While the competition law in this country is a bit early, it was established in 2015. There's no case reported too. Yeah. So the question is there inevitable tension between intellectual property rights and competition law in ASEAN perspective? My answer will be time to tell in this region. Perhaps most of the emerging market in this area are doing more on productions and also manufacturing. So we are relying on foreign IPRs to govern and control. Local government and perhaps most of the government in ASEAN are trying to protect foreign investment. At the same time, they try to leverage with competition law more on anti-forfeitoring dominant positions, whether it's vertical or horizontal positions. So what I can conclude is that it could be in future conflicting, in which case that it will be harm to society in terms of reduced welfare. Yeah, so I think that is the short presentation from my side for the ASEAN region, and I welcome any questions. Yeah. I think I end my presentations.
Thank you, Dr. Leong. It was a really nice insight to understand about the different Asian countries, including your country. And I'm sure like there will be a harm to the society. I also personally agree with your conclusion. So thank you so much for the presentation. So we can switch to the technical team. Can you please hand over the co-host right to my colleague Dennis Duncan? So hello Dennis. So this is I'm particularly interested. I look forward to listening to you, and I'm sure you're going to add on, and we are going to talk about the recent developments happened in the United States about this same topic. So over to you.
Yeah, thank you, Dev. Thank you very much for inviting me. I'm looking forward to this panel, a discussion on some of these topics which are beginning to take shape here in the United States. For my talk, I'm just basically want to start out first by talking about the statutory. Wait, I have two screens. Let me try that one more time. Share. Are they showing up? Are they both showing up?
Yes, we can see your slides, Dennis. Yeah.
Okay, very well. Well, let me start off by talking about we in the United States, we have a statutory scheme for patent rights, and we also have a statutory scheme for the antitrust laws. The statutory scheme for patent law comes straight out of the Constitution, which Clause 8 provides that the Congress shall enact laws for promoting the progress of science and useful arts. On the other hand, the antitrust laws are actually just, they don't have a specific clause, but they are under the Commerce Clause in the US Constitution. Through congressional act, there have been three laws passed, one being the Sherman Antitrust Act, the second being the Clayton Act, which is more geared towards mergers, and then the other one is the FTC Act, which created the Federal Trade Commission. As far as enforcement, you have the DOJ Antitrust Department division jointly with the FTC sharing responsibility over that. And also for the patent, that is, we have a director who puts forth and runs the patent office, which regulates and provides guidelines for the issuance of patents. As you know, a patent provides exclusive rights for excluding others from the use of the subject matter in those claims. So what I wanted to talk about are some emerging issues that have been, some of them we've been dealing with for quite a while. First, I wanted to talk about this one case that's been hanging around since 2019, initiated by Apple and Intel against Forest Management Group, which is a company owned by the Japanese SoftBank company. And what Forrester has is they own several patent assertion entities. These are entities that are non-practicing entities. They're not like a company like Apple or Intel that actually create products or anything. They merely accumulate patents and then either through contacting particular companies seek to assert and extract licensing fees, sometimes excessive licensing fees from these entities. In this particular case, what happened was the Forrester Group has been, through these various entities, has been, according to the allegations in the complaint here in 2019, these entities have there are two claims here: aggregated massive portfolios of weak patents covering electronic products and aggressively enforce those patents by demanding licensing. The one company called Unilock, which has been around since 1992, has filed about 25 lawsuits against Apple. Another entity called VLSI has filed 6 lawsuits against Intel, more recently in May, getting an award of $2.7 billion against Intel. Obviously, this is an issue for these companies. And as far as what they have sought to do is to bring this under, as you know, obviously, whether or not patents are weak or not, that should probably be under the jurisdiction of the patent law. But here they're arguing that these campaigns should be directed to under the antitrust laws, as they're going back to the U.S. Constitution, that they're causing a problem as far as promoting the progress of science and useful arts. And also there's even an undertone of fraud here, that this allegation that they're accumulating these portfolios for the purpose of extracting license, yet they know the patents are sort of weak. So this case has been going on, like I said, since 2019. The original complaint was dismissed with leave to file an amended complaint. The judge in this case, this is situated in the Northern District of California. The case I mentioned earlier, VLS, that was in the Western District of Texas. The reason I mention that is the two jurisdictions. One is a more pro plaintiff jurisdiction, which is the Texas jurisdiction. And then you have the Northern District, which is supposedly a little more friendly to the other side, Apple and Intel being located there. But this is they filed the first one, it got dismissed. They weren't able to show specific markets or the specific harms. I mean, stepping back for a minute, looking at, the fact that you have a patent, does it mean that it's attached to the actual entity who invented it, or is it a piece of property? Just like you in the United States, I own a house, I can go and sell it to anyone, and they can go and assert, the property line. No one can go on to the property. Just that's basically what's going on here, is that Forrester's entities have acquired patents from major operating companies who have sold or assigned those patents to these entities, and these entities have gone out and asserted them. And this is sort of an issue hanging out, because they filed the second complaint, and that also got dismissed, again, lacking a clear case of how this affects the market. And really what's going on here is they're seeking some sort of way of getting the courts to intervene to stop these campaigns. But yet they do have, at least some of the patents are actually valid. So this is an issue that's going to be going on. The second one was dismissed, but there's going to probably be another one, or possibly an appeal up to the maybe even to the Supreme Court. So this was just an issue sort of hanging out there. So what I want to do is jump to, can I change this? Yeah, here we go. So now, as you know, we have a new administration now. And with the new Biden administration, it has caused a significant change in policy. Being, like I mentioned, we have the FTC and the antitrust division of the DOJ who have jurisdiction over this. And what's going on here is we have a new FTC chair who gave a speech in October, sort of indicating what is important to her and what she will direct the agency to do as far as her enforcement of the antitrust law. And telling here was this statement in this speech she gave to the ANSI organization, which is a entity that deals with standard essential patents and other standards related issues. She indicated here that contract law may not be sufficient to address FRAN. FRAN is basically, I don't want to go into the dig into the weeds here, is basically what the FTC commissioner here is saying, that normally when you're licensing to one another, it's a contract law. It's up to the parties, bargain of the, your law students on there. I'm sure you're going through, this idea of bargaining for exchange, consideration. What's the basis of the contract? That is what should govern the licensing agreement. And this is sort of dealing with a prior decision last year where the FTC had sued Qualcomm, and a Northern District Court judge had come up with a decision in the district court saying that basically it's not a contract issue, it's an antitrust issue. She was reversed in the Ninth Circuit. And what was strange about this statement is the new FTC chair is basically saying, okay, I get that, but we're still going to go and look at this as a possible way to come forward and use the antitrust law, even though we have this decision here in FTC Qualcomm. So it was sort of an alarming statement, and there was some other language in that speech that basically said they're going to be very aggressive and seek to enforce the law here by that agency. So just as you know, she's just come on board, so it's going to be wait and see. But just to see what's coming forward under this new administration. Now, the DOJ and the USPTO have come up with policies over the years to jointly address various issues, again, addressed towards standard essential patents, which are patents that read on international standards, like your cell phone or whatever. You have the LTE, which is a 3GP standard, or you have your video, your MPEG standards. They've come up with enormous policies over the years, but there's a list of 11 issues that the DOJ and the USPTO are interested in having stakeholders come forward. They put out a call for comments, and these are some of the issues that they're asking for the parties to discuss. And naturally, what will happen is they'll come forward and they'll put out a new draft, a document outlining what the various stakeholders are required as far as their conduct in these different aspects of developing standard essential patent portfolios and how they will license them. So this is new. We have a new, like I said, a new antitrust division, Jonathan Cantor, who we're still waiting to see exactly how he'll run that agency. So we're early in the administration. There'll probably be more direction here. I didn't want to go too deep into cases. Like I said, I mentioned the one case only because it brings an interesting issue up of whether or not, in the United States, you have valid patents, you transfer them to another entity, they tend to accumulate them together and then launch campaigns to license them, whether or not, we want that to happen, whether or not that's actually, going to go against this whole notion of promoting the progress of science and useful arts. If you've got companies like Apple and Intel and others who are being strangled by these fellas. So that's basically some of the stuff I wanted to bring up with these issues, and just to inform you that there are new changes coming here. So let me hand it back to Div, and we can hopefully have some questions and answers at the end of our panel. Thank you.
Dennis, before you end, I just wanted to have a small clarification on the point number 6 on the slides. The question, the draft DOJ policy says that, are small business owners and small investors impacted by perceived licensing inefficiencies? Oh, I lost the slides. So you understand? So
yeah, well, this is something interesting because I didn't mention this is also in the FTC commissioner's speech too, and also coming out of the EU, which maybe one of our other speakers is going to mention, is that there's been an emphasis in antitrust and competition law on the effects on small to medium-sized entities. So this is very good news for the U.S. that we are going to be focusing on, how licensing agreements and licensing assertions by these entities will it have an effect on these small, medium-sized entities? And it's good news to know that that's going to be within the scope of this current inquiry. So maybe we'll get some good guidance out there that can help the small to medium-sized entities.
Looks like, yeah. So Jay, you have raised the hand. So as always, Dennis, it was really wonderful to listen to you, and really you touch upon very important things. And I'm sure like this draft DOJ policy is going to big help for the kind of mess created in the United States. So with this conclusion, I would like to call my colleague Jay Su, another, though he's also US patent attorney, but working in South Korea is a lot of interesting, and South Korea particularly has seen biggest litigation in this particular domain where the FTC, and the anti-commission law guys have came into picture. So I would love to listen from Jay. So what do you, Jay?
Okay, thank you very much, everybody, and congratulations to the MIT World Peace University for hosting the first International Symposium on Law and Peace. And like Professor Milton mentioned, law and peace is just a great, I think, term, and I think we all work towards law and peace. And let me share my screen as well. And I'm glad that I'm going last in the sense that, let's see, can you see my screen?
Yes, sir, we do.
Okay, and let me see if we,
I cannot see. Is there any problem?
Okay, can you see now?
Yes, yeah, very well.
Okay, yes, oh, well, again, thank you again for Divyan for inviting me. And yeah, I'm very fond of India because India is one of my favorite countries, as I lived in India for 4 years in New Delhi when I was young, but it was the best time of my life. So I'm very excited and thrilled to be speaking today. And again, going back to Dr. Milton, Professor Milton and Dr. Young, they talked about the different perspectives of IPR versus competition law. And then Dennis, I'm really happy that I'm speaking after Dennis because I'm kind of going into more detail of the SEP, the standard essential patents, because I've worked for a big electronics company in Korea for more than 9 years on their SEPs. I'm a computer engineering background guy, so I did a lot of the SEPs for them. So I have some perspective on that. And moving along, I'm going to be mentioning basically the IP and competition law and how conclude by commenting on how IPR and international cooperation should take place moving forward. And well, starting off, both intellectual property and competition law pursue the aim of enhancing economic welfare, promoting innovation, which is a common scheme. However, their objective seems to be in conflict, whereas IP law focuses on the reward of inventive effort and the inventor's incentives and innovate by conferring an exclusive right and use of the invention, whereas the competition law system that maintains market order and maximizes consumer welfare by prohibiting or rectifying any anti-competitive conduct or system, and emphasizes the dissemination of innovation by ensuring diffusion and access. I have a lot of slides, so I'm going to be going very fast because the time is limited, and so maybe I'm just going to skip some of the wordings. But Korea is very developed in the sense that it's a very high-tech country. As you know, we have the Samsung electronics, we have the LG. So a lot of the smartphones, handphones are coming from Korea. So this standard essential patents, which I'm going to be talking a lot today, is very, I guess, highly developed compared to other Asian countries, I would say. And patent ambush is pretty frequent because it's where a company hides the fact that it owns the intellectual property rights, essential for standard in the process of discussion for the designation of standard technology, a violation of FRAND. Dennis mentioned about FRAND, which is the fair, reasonable, and non-discriminatory commitment while granting standard essential patents, license abuse litigation and reverse patent agreement to settle patent disputes are examples of where the competition law enforcement kicks in. So let me go in a little detail, but I'll try to be very brief. The Korean law, the Article 59 of the Korean Monopoly Regulation and Fair Trade Act stipulates that the act does not apply to the legitimate exercise of IPRs. However, so it means that the act should be applied in case where there is a unfair exercise of IPRs beyond the scope of its purpose of recognizing the rights. And in year 2000, the Korean Fair Trade Commission, which is comparable to the FTC of the US, established the guidelines on unfair exercise of intellectual property rights. However, this is updated in 2016, which I'm going to be talking later on. And in Korea, as I mentioned, the so-called patent wars between global smartphones giants have impacted the global SEP market. There are injunctions sought by SEP holders and patent privateering by NPEs, the non-practicing entities. And this, I think, was the biggest impact of the IPR versus the competition law, which came in December of 2016, where the Korean Fair Trade Commission surprised the whole world by taking a decisive action against Qualcomm in this alleged abuse of IPRs. So in essence, it's kind of different from the current US view, where the current commissioner of FTC is emphasizing more on the contract law than the unfair competition law, whereas in Korea, the unfair competition law kind of prevailed over the IPR licensing agreements. So I don't know if I should go through all these, but these are some examples of unfair exercise of the standard essential patents is acts of unfairly not disclosing information of patents applied for or registered in order to increase the possibility of being selected as a standard technology or to avoid prior consultations on the conditions of granting of license. And this is the patent ambush, and also acts of avoiding or circumventing licensing on brand terms to strengthen market dominance or to exclude competitors, and acts of unfairly rejecting the licensing of SCPs, and acts of unfairly imposing discriminatory conditions when licensing SCPs, or of imposing a reasonable level of loyalty. And well, the Korean, they view this, the filing lawsuits views as abusing IPRs are, one could be an act of filing a patent infringement suit while the licensor knows that the patent infringement is invalid or the patent is invalid, or an act of filing a patent infringement suit despite the fact that it is objectively clear that infringement is not valid. And so in 2016, they revised the guideline. So now it's more clear distinction between the SCPs and de facto SCPs. And for the students out there, well, let me just give you that de facto SCPs are the technologies used as standards in relevant industries through competition, and SCPs are adopted by the international standard organizations as a standard on the condition that patent holders are voluntarily committed to FRAND terms. So the new guidelines gave clear distinction on those, and also the clear standards for assessing unreasonableness of patent holders rejecting the grant of non-SCP. So these were some amendments made, and it all became to this one big case of Qualcomm, where Qualcomm declared to international standard organizations, including the ITU and ETSI, that it would commit to FRAND terms, so that its cellular communication technology can be adopted as an industry standard, and that is what standard is, as Dennis mentioned before. And however, despite this the friend commitment, Qualcomm refused requests by competing modem chipset manufacturers to license the cellular SEPs that are essential in manufacturing and selling the chipsets. And Qualcomm, instead of they entered into incomplete agreements that restrict to whom they can sell or coerce them to report sensitive business information, such as their sales amount, product model, or name of customers, etc. And furthermore, in order to gain the upper hand in license agreement negotiations with handset makers, Qualcomm threatened that it would suspend its chipset supply to them. And as a result, the Korean Federal Trade Commission viewed that Qualcomm's refusal to license its SEPs to competing chip makers restricted their sales channel, and competing chipset makers could face a patent attack from Qualcomm if they sell their chipsets to handset makers that are not licensed by Qualcomm, or to handset makers that are in dispute with Qualcomm. And as a result, competing chipset makers could only sell to handset makers that have signed a license agreement with Qualcomm, making it difficult for them to actively do business in the handset market. And as a result, accordingly, Qualcomm's chipset became products safe from patent attacks, while competitors' chipset became flawed products without patent licenses. And this created a competition structure absolutely favorable to Qualcomm, i.e. Becoming an unlevel playing field. And the decision, which came in 2017 January, recently the KFTC, the Korean Federal Trade Commission, announced their history in the last 30 years, and this was the biggest case they dealt with. And they imposed a remedial orders and an administrative fine of 1.00 trillion won, which is about 900 million US dollars. And this never happened in Korean history. So it was a big case. And again, like Dennis just mentioned before, it was kind of the opposite of what happened in the US recently. So that's kind of an interesting point. And the orders included the following: upon more than chipset makers' request, Qualcomm should engage in good faith negotiation for patent license agreements. Qualcomm should not coerce patent license agreements by using its modem chipset supply as a leverage, and should amend or delete the relevant provisions in the agreements. And in concluding a patent license agreement with the handset makers, Qualcomm should not coerce unfair agreement terms, and upon the maker's request, Qualcomm should renegotiate existing patent license agreements. And so this is the last slide, where this is the post Qualcomm era in Korea, where the most IPR cases involve information and communication technology, the ICT, and the information communication technology cycle is very short. And the market environment changes drastically, and therefore promptness is a key factor in enforcing competition law. And here, I think the advantage of Korea being a kind of a leader in this area is because, you know, Korea, South Korea, it's a very small country, but equipped with a lot of high technologies. So when there's a law enforcing IPRs or enforcing the competition law, things can change very fast. Unlike US, which is huge, and they have to go through different layers of law enforcement, like the DOJ, the FTC, the patent office. But I guess in Korea, things can be done faster in that sense, even though that ICT is really complicated, and it's a long time for judicial reviews. And but I think this 4 points would probably the global perspective is that most intellectual property rights are registered all over the world, and it affects the entire global market. And US, EU, China, Taiwan, as well as Korea, they all have brought Qualcomm case to the courts or already imposed corrective measures against this abusive conduct. And in order to achieve the common goal of restoring competitive order in the market, I think it's necessary to promote cooperation in enforcement between competition authorities in a consistent manner. And as for the intellectual property rights abuse cases, it is necessary for each competition authority to garner successful enforcement experience by spreading the successful cooperation model for international cartel cases to the IPR abuse cases. Well, I guess it's going to be much harder to get them done, but I think that's the Korean perspective of where the competition law versus the IPR rights are in, right now. And yeah, we'll see, because it's very interesting to see how the US will develop. And I think there's a tendency that Korea also will follow the US EU approach as well. So that's my take. And let me give the mic back to Vivienne. Thank you.
Thank you, Jay. Before I start the question answer session, Jay, I just wanted to ask you, please don't take me otherwise. Do you really think there is a successful cooperation model available in this world?
Well, I guess we have to try. I mean, and I think there have to be a lot of different models, but emerging into some kind of a cooperation model. But I don't think there could be one model. Yeah, yes. I agree on that point. Yes.
Thank you so much for the very interesting perspective from South Korea. And I keep hearing about the Qualcomm and KFTC, matters, like, almost every month, in newspapers and in social media, these guys are fighting with each other. And I'm like, I was not aware, like, it was imposed about $900 million fine. This is huge. This is huge. So thank you for the presentation. And with this, like, we have concluded today's panel discussion about the conflicting part. So my part is over. So I would like to hand over to Professor Bakshi to take you further. And thank you all my colleagues and panelists, co-panelists to be here. It was really interesting to listen from you guys. Thank you so much.
Thank you. Thank you so much, sir. It was indeed pleasure having this very insightful discussion. And in fact, sir, I was requesting you, and of course, with your permission, Verma sir, we would like to have questions from our student volunteers, because they are eagerly waiting to have a dialogue with our experts. So, sir, with your kind permission, maybe have the students asking a few questions to our panelists.
Sure, we have 10 minutes for that. So yes, please.
Right. Thank you. Thank you so much, sir. So the first question is from Manvi Sharma, School of Law, MIT World Peace University. And I would request her to ask the question to Dr. Milton Barslos. Manvi, over to you.
Greetings to all. Am I audible?
Yes, you are.
Yes. So my question is, can competition law become the to control the theft of intellectual property rights in the corporate and IT world?
I'm really sorry, I didn't hear you quite well. Can you repeat the question, please?
Sure, sir. The question is, can competition law become the weapon to control the theft of intellectual property rights in the corporate and IT world?
If competition law can be the way to control IP rights, am I correct with my assumption? Is that the question?
Yes, doctor. Yes, that is the question.
Yes. Ah, okay. Sorry, I had some gaps. I believe the whole law system is able to restrict IP rights, not only the competition law. And when I say that, it's based on the assumption of Professor Pedro Barbosa, when he says that the IP rights has a polyhedric relation. That means it's consumer law, it's contract law, it's competition law, it's the public administrative law that will restrict, when needed, the IP rights. So I would say that yes, is I think the whole law system is supposed to be an harmonized system. And when you cross the line in each of those systems, you have reaching another system that is being abused. So yes, in this sense, I can say that the competition law is a way to restrict the IP rights in order to keep with the goals and the objectives that the IP rights are made for. So yes, and then this is an interesting question, because it seems to me, and for most of the people that write about IP rights, is that you do not have a natural right for a property of an IP right. So you have a goal to accomplish when you have the IP right. So once you are disconnected with this goal, you start to be disconnected with the law system. And that's the reason that, yes, in this sense, I can say that the competition law is made for restrict the IP rights when they are getting out of the goal they are built for. I'm not sure if I answered your question, but did I?
I think so, sir. It was very well answered. And thank you so much indeed for that intellectual feast. And I now kindly request Ms. Suhasi Palle to ask the next question to Dr. Leong. Suhasi, over to you.
Yes, ma'am. Am I audible?
Yes, you are.
Okay. So, sir, do you think intellectual property laws are given more importance as compared to antitrust laws?
If you look at the perspective of my region, I would think it should be a balance. But if you think to the point of the modern countries, which is they think that creativity is more important than competition, that will be different perspective. So to answer your question, my opinion, I think that depends on where you are in what country and which level you're in. And if you look at my region, in ASEAN region, I think we are more on the leveraging on competition law, while at the same time, we also don't want to kill the creativity of people who create the new things and progressing in science and technology. So to me, personal opinion is there should be a balance. There should be a check and balance on certain things. Of course, as I repeat again in my slide, is hope that you will not create a conflict to the roots or the welfare of the society. Otherwise, I think a IPR law could be a threat to will be a conflict to competition law in the future. Yeah. So I hope that answers your questions. Yeah.
Yes, sir. Yes, sir. Thank you.
We truly, with these checks and balances, I think we can definitely have saw conflict IPR law. Let's hope for the best.
Yes.
I now request Ms. Isha Sinha from School of Law at MIT World Peace University to kindly ask the next question to Mr. Dennis Duncan. Isha, over to you.
Am I audible, ma'am?
Yes, you are.
Greetings to all. My question is, what are the conflicting elements between IPR and competition law?
May I kindly request Mr. Dennis Duncan to unmute himself?
Sure.
The question is, yeah. So do you want her to repeat the question?
Yeah, ask the question one more time.
Isha, please go ahead.
Yes, ma'am. My question to you, sir, is what are the conflicting elements between IPR and competition law?
Well, IPR, like I mentioned in my talk, was basically you have a patent that's granted and it gives an exclusive right to exclude others from making, selling, or importing goods. On the other hand, in the US, you have the antitrust laws, which restrain certain types of conduct and trade. And also Jay mentioned some of the activity in the South Korea, cartels, various types of licensing schemes that, like, Qualcomm's actually a good example of multiple very technical schemes that they put forward to extract licensing fees. That has, in the United States, they were able to get around it when Apple and Intel and others initiated the FTC to bring forward and bring great detail of the strategies they put forward. Like Jay mentioned, in South Korea, there were some ways that they would extract a licensing fee for the chip, and then the licensing for meeting the standards under 3GP or LTE or all these different types of standards, and then excluding the licensees from selling to others that weren't licensed, all these types of schemes. So that's sort of the scope of the antitrust laws, to prevent cartel type behavior. And I should also mention, it wasn't just like Jay mentioned that the Qualcomm had to pay $900 million to South Korea. The NDRC, which is in the Chinese equivalent of the FTC or KFTC, they had to pay, I think, $975 million. So there's a lot of money, a lot of fines that are being levied. Of course, Qualcomm can easily make that up in their licensing fees, but it's quite substantial. So the enforcers have the ability and the way to do it. In other jurisdictions, they've been successful. Here in the United States, it's been more nebulous as far as getting to the details of whether or not it's a contract or whether or not this is something within the purview of the antitrust regulators' capabilities. So I hope that answers your question.
Right.
Yes,
Thank
sir.
you.
Thank you, sir.
Thank you so much indeed, sir. And I now request Ms. Janvi Shirobe from School of Law at MIT World Peace University to ask her next question to Mr. Jay Su. Janvi, over to you.
Greetings to one and all. Thank you for this opportunity. So my question is, while doing business in India, parties are prohibited from executing anti-competitive agreements. What do you think about that? Why is it so?
Well, I guess, Divyendu, you're the one to answer this question. I'll give you the mic.
Not exactly. I mean, yes. Anyway, the question has been posed to you, but anyway, I'm happy to answer on your behalf, Jay. So the thing is that the point is, there is a lot of issues. You remember, like, when I started my talk, I mean, not my talk, I gave the introduction, and I touched upon very, very basic lines. What creates a conflict? Because the answer lies in that. The conflict arises when you have a advantage or dominant position in the market, right? And when you start abusing that position, the moment you start abusing position, there is a conflict between IPR rights and the competition law. That's how these two subjects are connected with each other. Now, coming to that, there are many back and forth, cases, writ petitions, infringement suits have been filed. Delhi High Court, Bombay High Court, where, like, the parties are leasing, like the CCI. CCI is the Competition Commission of India. They look after the anti-competition law in India. So they ensure that they do the proper investigation and they pass the relevant order as per the law. But what happens? These companies, I mean, the patent IP owners, they start approaching courts. These are not proper jurisdiction. They do not have jurisdiction to investigate. They do not have this and do not have that. So I mean, if you're really interested to understand the very nuances of this particular topic, I would request you to go through the recent case of the Monsanto, which I informed other audience also. Monsanto Holdings versus Competition Commission of India. It was decided by Delhi High Court in May 2020, and where this Delhi High Court, they have examines the complaint filed by the petitioner, and they have very particularly says that, I mean, the Competition Commission of India, if they have the jurisdiction to, if someone has filed any cases of abuse of patent rights or IP rights, they have a jurisdiction to investigate. But however, that investigation report has to be submitted to the court to decide the final outcome. So I think this answers the question.
Yes, thank you so much.
Jay, you want to add anything from your perspective? Yes, feel free.
No, I think you answered it perfectly.
Well, thank you so much. In fact, the next question is for Mr. Divyendu Verma. Well, but we will request both Mr. Jesu and Mr. Divyendu Verma to kind of answer this question, for which I'll request Mr. Prithvi Kapoor from School of Law at MIT World Peace University to kindly take over. Prithvi, over to you.
Thank you, ma'am. Firstly, I would like to thank all the panelists for such an enlightening speech. I'm really grateful to be listening to this. So my question is to Mr. Verma, sir. So my question is, what flexibilities does the TRIPS agreement allow to foster technology transfer and consumer welfare in developing nations?
So when you talk about, Jay, I would like to talk about the TRIPS agreement from the Indian perspective, right? So if you would like, you can add on that. So the whole perspective of adapting TRIPS agreement by India was to comply with the agreement, right? And in order to when you sign any agreement, you have to comply with certain orders, right? So for example, one of the best outcome, I mean, if you ask me particularly, being an IP professional in India, I would say the biggest change India has seen when they adopted the TRIPS agreement was the creation of Plant Variety Protection Rights and Farmer PBFRA Act, right? That was because there was a provision to have a separate law on the Plant Variety Act. So likewise, there are many aspects, finer aspects, which has been before signing those agreements, has been accepted by the India, and they have amended the Patents Act. They have made certain amendments in Section 2 and 3, if you see, and thereby they have created a lot of provisions. The plant variety, for example, plant varieties are not patentable subject matter, for example, and for that they have a separate act altogether. So likewise, there are many considerations which is adopted by the Indian government in order to comply with the TRIPS agreement. Now coming to specifically to the IP rights abusing of the dominant position in the market, vis-a-vis having the IP, you are owner of the IP right. So it's all about the balancing, because there the TRIPS is silent. TRIPS only provides the guideline, how to you conduct yourself, how to conduct the business, how to do this and that. But the point is that now you have both the law. And Delhi High Court clearly says that both the law, Patents Act 1970 and Competition Act 2002, are they are complementary to each other. There is no point of confusion or conflict. So there is a requirement of the law, and thereby the government has enacted it. So it's all about how you balance the power, how you balance your position in the market. And if you're not able to balance your position, you are dominating, there comes the CCI, right? So this is kind of a flexibility has been provided. There is no, I would say, godfather looking after you. Ultimately, if you are the patent owner in India and you are allowed to enjoy your patented rights, if the patent is granted to you, it's all depends on you how you enjoy, right? There is a lot of social as well as the legal responsibilities on you. Jay, you want to add anything from your perspective?
Yes, for the TRIPS agreement, I think the two aspects are very important, which is the enforcement issue and the dispute settlement issue. And since it's an international agreement, the enforcement can be difficult. But as far as the dispute settlement, I think the countries all around the world, like I said, the model of corporate international cooperation should also impacted by the TRIPS agreement, especially in the dispute settlement area. But just to give you a quick overview of what's going on in Korea, is that there are two conglomerates, like two very big companies in Korea, and they're suing each other, not in Korea, but in the US, because the money and the law. So it is hard to say that the model is starting to get there in Korea, but yeah, so we'll see. I mean, I guess still the money talks, and where you can get the judgment. I still think, like Dennis says, in the US, there are different courts, different states, some courts in Texas. I mean, Texas court, Eastern District are plural plaintiff, whereas the California courts are like pro-defendant. So yeah, I mean, but then again, going back to the TRIPS agreement, I really hope that dispute settlement issues are being talked more, and the authorities should probably come up with some kind of a model. And I think this whole law and peace is a good start. Hopefully that we can all merge into that.
Yep. Dennis, you want to add anything on this?
Yeah, I would just add, I didn't want to get into this issue because it's a very convoluted and complicated issue, but Jay is alluding to another issue of forum shopping. And this is particularly using India, targeting India to go after Chinese companies. Companies such as InterDigital and some others have used India in order to try to force a worldwide licensing agreement. Other jurisdictions have been used, such as UK and EU, to try to do this. And this is something else that, this is a great forum to try to start this conversation, and hopefully future talks will start to dig in deeper into this issue, as it is affecting, I think, how these disputes are settled, because allowing forum shopping really ultimately just, delays a decision and makes uncertainty into the market. So, just wanted to add that, but trying not to bring in added, obscuring some of the topics. So, but just say for a future talk, it'd be great to get in more into that detail as it progresses.
Thank you, Dennis. Really, I'm like, I have this in my mind. And this particularly, it's a kind of a material of a separate session altogether. Forum shopping is very important. I think we should be talking in detail, not in very hurry manner. Probably we will be meeting very soon for another a talk show where we should be talking about this. And I particularly am very interested because this is very pressing issue, and India is really facing a lot of trouble because of that. And it is really wonderful to again speak on this. Thank you again for adding your 2 cents. All right. So I think we have concluded our question and answer session. Dr. Bakshi.
Right, we have, and indeed it has been a very enriching discussion with all our dignitaries on the panel, because honestly speaking, our students have enjoyed this. They were really looking forward to strike a dialogue with all our experts. And thank you to Mr. Divyendu Verma for almost giving us a channel for planning on the session in the 2nd edition of ISLP, because I think we all have probably kept a gateway where this can be continued in the 2nd edition of ISLP. So we will surely meet soon, hopefully in an offline mode and not in an online mode. Well, thank you so much. And I now request my technical team to kindly display the resolution for this session. So dear participants, it's time to vote for the resolution of this session. You'll have exactly a minute to cast your valuable poll, and simultaneously I'll be reading out for all of you. Well, we, the participants of the first International Symposium on Law and Peace, hereby promise that as future law professionals, we will protect the interest of the consumers by striking a balance between intellectual property rights and competition laws, which will ensure creative and innovative ideas being launched in the market for the overall prosperity of the economy. Dear participants, you have exactly a minute's time and I think just a few more seconds left to cast your valuable vote. I'll request you to vote for or against the motion as per your choice, but I'm sure you will definitely do it with due diligence. So I request my technical team to kindly display the voting results. And well, a huge round of applause. 99% of people have voted for the motion. Well, that's amazing. This
That's
was
interesting. That is interesting.
Yes, absolutely, sir. And thank you so much to all for your wholehearted participation, for administering the oath. I now request my technical team to kindly display the oath, and I'll request our student representative to be ready, before which I will ask Mr. Jesu to address since he has raised his hand. Yes, sir. It's okay.
Wrong. I clicked the wrong button. I'm sorry.
Fine, that's absolutely fine, sir. I request my technical team to kindly have the oath displayed, and I request Ms. Simran Bafna from School of Law at MIT World Peace University to kindly read the oath of the first ISLP. Over to you, Simran.
On the platform of MIT WPU International Symposium on Law and Peace, we, the sons and daughters of Mother Earth, being the global citizens, assure to abide by the duties and responsibilities of an ideal citizen, and hereby affirm that we will endeavor to promote peace and harmony through the lens of law in the pursuit of justice. Thank you.
Thank you. Thank you so much indeed. And as we proceed towards the conclusion of this session, may I now kindly request Dr. Ganesh Pokle, the Controller of Examination at MIT World Peace University, to please propose the vote of thanks and also give the concluding remarks for the 6th session of first ISLP. Sir, over to you.
Yes, thank you, Dr. Bakshi, for handing over it to me. First of all, I'm very thankful to the School of Law team, Dr. Purnima, head of the school, Dr. Anuradha Parashar, Dean, faculty, for bringing out this very important topic for a discussion, giving an opportunity for all of us together to hear out the expert talks on this topic, where actually we are in a challenging time. The equilibrium of the world is shifting because of various challenging environment like COVID, a lot of power shiftings, business trades, and all of it. So for the way it is said, to bring out the peace, we need a balance, we need a harmony, we need an equilibrium. And at this right time, bringing out this topic through this International Symposium of Law and Peace is a very appropriate time. So I am thankful to the team, School of Law team, for bringing out this very important topic. I'm also thankful to all the speakers for a very crisp, very accurate, very focused giveaway to all the students. I'm sure they all have got a very clear understanding about this topic. I'm thankful to Professor Dr. Milton, Dr. Leong, Mr. Dennis, Mr. Jay, for being here, answering the questions very enthusiastically, very accurate manner. In addition to that, I'm also thankful to Mr. Devendra here. He could actually made us sailing through very easily in a very equilibrium way through this very difficult topics called as IPR, competitive laws, and all of it. So thank you to the panelists. Thank you very much for making the session very enlightened and raising the bar of the expectations, objectives, outcomes, and the standards of the conferences with your participation. Thank you once again for that. I'm also thankful, rather I'm more thankful to all the young participants in here for being a very interactive, very energetic, and very participative into discussion, without which all of us do not create the things. So thank you for being there. Students, if you see, when you hear all of these participants, things are very clear. In today's time, when we need to be very focused on the equilibrium, it's not at all sufficient to be just the student of a law. At the same time, one need to be student of the technology also. You need to be the student of psychology also. You need to be the student of a business also. You need to be student of a global affairs also. We are talking with the global thinkers in this platform right away. World has become a global village, so the challenges are tremendous. With the same time, so it's not sufficient to be just a student of a law. You need to be student of multidisciplines together. And then based on that, you will be equipped enough to go ahead. I'm very sure, Dr. Bagchi, I can see every speaker is worth to be heard for at least a half a day, and then having a lot of interactive sessions on top of it. Yeah. So with this, I again thankful to everyone. I'm also thankful to the management of the university, Honorable Vice Chancellor, our respected registrar, and obviously our motivator, our backbone, and our supporter, our Honorable Executive President Rahul sir, for giving all of us an opportunity, and obviously giving all of us a motive and a motion to make these wonderful things happening. So with this, I'm thankful to everyone for giving me an opportunity to be a part of this wonderful session and to learn a lot from the experts. Thank you very much with this. And I'll hand over to you, Dr. Bagchi.
Thank you. Thank you so much, sir, for sharing such valuable inputs regarding how, it's the need of the hour for all our student friends to think of multidisciplinary, in fact, transdisciplinary aspects. And I'm sure this panel discussion has fostered the minds to already start thinking in that direction. So thank you so much indeed for that amazing concluding remarks and also the vote of thanks. And now as we proceed towards the next session, which is about to begin at 7 p.m. sharp according to the IST, I would like to make a very important announcement, dear delegates and my dear participants. The next session, that is session 7 of the first ISLP, is on the theme Human Rights Law and Artificial Intelligence, the Roadmap. We have definitely screened all our dignitaries and the panelists. I'm sure you can view it on your screen. These all will be joining us very shortly, and we are exactly half an hour away from the session. I request everyone to stay tuned for the next session of the first ISLP, and we request all to be there with us, not just for this, but also for the last day of the first ISLP, which is day 4 on 17th of December, where the session 8 will be on legal education in 21st century, followed by an amazing valedictory session, which will begin at 4:30 p.m. sharp. So thank you so much to everyone. Thank you to our Honorable Dean Professor Anuradha Parasar ma'am. Thank you to Ganesh Pokle sir, as well as thank you to all our members who have definitely been a backbone of our success, and they have supported us in all their endeavors. We really can't thank